Hello and welcome to Rights and Recourse, a program that tackles constitutional, human rights and legal issues, bring you information and analysis. My name is Dumile Matez. Remember, you can also be part of our discussion today by calling us on 011 714 5497 or 5498 or tweet us at Rights and Recourse. Alternatively, email your thoughts to rightsandrecourse@sabc.co.za. On April 7 this year, as indicated in paragraph 16 of the heads of argument of the International Criminal Court, the Chamber invited South Africa to make submissions at the Article 87 subsection 7 hearings to explain, 1, whether South Africa failed to comply with its obligation under the statute by not arresting and surrendering Omar al-Bashir, and if so, whether a formal finding of non-compliance can be made and the matter referred to the Assembly of State Parties to the Rome Statute or the United Nations Security Council. This after the High Court in Pretoria handed down its judgment in the litigation challenging the procedural aspects of South Africa's decision to withdraw from the Rome Statute of the International Criminal Court. The application was brought in November last year after South Africa delivered its notice of withdrawal to the United Nations. Today on Rights and Recourse, we explore the implications for South Africa's standing both at the United Nations Security Council and its international standing. To discuss today's topic, we are joined in the studio by Ms. Anneke Meerkotter, Director, Southern African Litigation Centre, Mr. Jeffrey York, the Africa correspondent for the Globe and Mail in Canada, and from Pretoria, we are joined by Ms. Ottilia Maunganidze, Head of Special Projects at the Institute of Security Studies. And lastly, on the line from Durban, we're joined by Professor Dire Tladi, Department of Public Law of the University of Pretoria, and also an advisor to the Minister of International Relations and Cooperations. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse. We'll start with you, Professor. As a professor on the line, Professor, we'll start with you. How important was the fact that South Africa had to explain itself to the ICC regarding the arrest and handing over of President Omar al-Bashir?
Well, look, it wasn't really anything extraordinary. It's normal that when there's been a case of what might appear to be non-cooperation, that the pretrial chamber would want to make a decision based on observations from the state that is accused of non-cooperating with the court. The only extraordinary thing, which really makes it different from all other cases, is that in this instance, the pretrial chamber requested South Africa to make an appearance. So it wasn't just written observations, it was actually an appearance, but also that it was a public hearing. So in the past, there's been many cases like this. There's been 11 cases of alleged non-cooperation, and this is the first time that you've had a proper hearing of all the legal issues that pertain to this particular issue. So that's really what makes it significant.
It would seem that the ICC did not mince its words in dealing with this case of non-compliance against South Africa, especially if one were to deduce from Mr. Tafu's statement, quoted as having said, there was no ambiguity about South Africa's obligation to arrest al-Bashir and no provision in the domestic law not to arrest him. What was your defense?
Well, in fact, so we attacked that particular statement by Judge Tafusa, who's also the presiding judge in pretrial chamber, by showing him that in fact it's both as a matter of law and as a matter of fact simply not true to suggest that there's no ambiguity, and how we showed him that there was no ambiguity or that it's not true that there was no uncertainty was by referring to the number of academic articles on this issue which provide different views and suggest different views. And then going further and saying that if you look at the academic literature, even those articles that tend to agree with what the ICC has previously said offer different, sometimes conflicting legal basis for that. But we went even further. and said even within the jurisprudence of the ICC itself, the legal bases that have been advanced for why there's a legal duty to arrest Mr. al-Bashir are not only inconsistent, but in many instances, mutually exclusive. So, in other words, the decisions in some instances are so contradictory that they cannot make sense when you put them next to each other. So we attacked that particular line of argument to say that it's not true to say that everything is clear and that everything is uncertain, that there's no ambiguity. But then we went even further and said, if anything is clear, is that if we divorce ourselves from our emotional and our policy preferences, the law is in fact clear that there is a duty not to arrest Mr. al-Bashir, both as a matter of general international law and as a matter of the Rome Statute.
Professor, with respect, those issues were ventilated at the North Gauteng High Court at the start of the case, also ventilated at the Supreme Court of Appeal in South Africa, and the issue that was made by the ICC was not anything new.
I beg to differ very strongly, and this is a point that we tried to make before the ICC, in that the High Court, the Supreme Court, if it had reached the Constitutional Court, then the Constitutional Court, those courts address different matters. The law that is applicable before those courts is domestic law. The ICC only has jurisdiction to deal with the Rome Statute and international law. Now, the High Court decision was very bad. It was a very bad decision, so I think we should forget that decision. But if you look at the Supreme Court of Appeal decision, which is really the decision that is now law, the Supreme Court of Appeal, in fact, let me pause here and say that what many people don't realize is that, in fact, the Supreme Court of Appeal decision is consistent with the government's position. Because it is true that the Supreme Court of Appeal said there's a duty to arrest Mr. al-Bashir. But read the decision very carefully. It says under domestic law. So it is the Rome Statute Implementation Act, the Domestic Implementation Act, that in the view of the Supreme Court of Appeal creates the obligation. The Supreme Court of Appeal goes through at length to look at international law, and it comes to the conclusion that under international law, there are no exceptions on the duty to respect the immunities of Mr. Bashir.
But then Professor, with respect again, I did read that judgment. With Professor, with respect again, I did read that judgment from the Supreme Court of Appeal, and the government was represented by no less a person than Jeremy Gauntlet SC, and the court actually said South Africa did not yield to what the government was saying.
No, but you see, that's the thing, Dr. Mr. Mateza. I'm going to be what's the word? Firm with you. You must listen very carefully to what I'm saying. I'm saying to you, it is true that the Supreme Court of Appeal said that there was a duty on South Africa to arrest Mr. al-Bashir. That's true. What I'm saying to you is, if you read the judgment very carefully, it has nothing to do with who represented South Africa. If you read the judgment very carefully, it's very clear what the basis for that duty is. And the basis is not international law. Because if you read the judgment as carefully as I've read it, and I've read it many, many times and written articles on it, if you read it very carefully, it says under international law, South Africa is obliged not to arrest Mr. al-Bashir. And then it says, but actually it doesn't matter, because the way you as the government have implemented the Rome Statute is to go beyond what the Rome Statute actually requires you. And you have said, you as a government, you will not respect immunity. So it is because of the domestic law, that there is a duty to arrest Mr. al-Bashir, notwithstanding his immunities. That is what the judgment said.
The
So
other thing,
that's what a lot of people don't realize, but that's what the judgment said.
Professor, let us just get this. South Africa has withdrawn its notice of withdrawal from the from the ICC. Is that the case?
Well, yes, I think that's the case.
Where does this place us? Are we still members of the? Do we still belong to the Rome Statute, or still members of the ICC, or have we decided we're going to wait until the ICC makes that determination?
I mean, look, we are still a party to the Rome Statute. We're still a member of the ICC. In fact, even while before withdrawing our notice of withdrawal, we were still a member of the ICC. We would have been a member until October. Now we have withdrawn that notice, so we are a member full stop. As a matter of law, that's the only thing that's relevant. Nothing else is relevant. So it's of course true that the government might decide to restart the process, but I mean that's just I don't know if the government will do that. It may or may not. But as things stand, we are a party to the ICC statute. We are, and so we are a member of the ICC.
The other thing, I would want to believe that the relief given by the Supreme Court of Appeal with regard to domestic law makes reference only with regard to the implementation of the Rome Statute Act number 27 of 2002. Am I wrong?
Yes, that's correct. No, you're correct.
That is the domestic law we are referring to here.
Right.
What happens now? I read somewhere in my research that South Africa might be referred for non-compliance to the Security Council. And I said to somebody I was talking to, South Africa has never been to the Security Council for something that is against the United Nations since its days in the as an apartheid state.
Well, I don't know about that. I think that might not necessarily be true, but I think that's veering off topic. I'm sure there have been cases, but let's also just be clear that this would not be the first time. Assuming that the ICC decided indeed to refer South Africa to the UN Security Council, this would be the 7th time that it has done that. And
with other
council, that's right. And the council has never acted on any of those referrals. So two things. One is perhaps the political significance of this is not so great because it's just one of those things that the ICC does. But as a legal matter, I think it also might suggest something else about the council's attitude towards these referrals, that it doesn't think that in fact there is no immunity, hence it doesn't act. Because in fact, the referral to the UN Security Council by the ICC is to say, the ICC is saying to the UN Security Council, look, here is a state that is ignoring you. And if the Security Council itself is ignoring the ICC, then I think that suggests something about the interpretation that the ICC has given to the UN Security Council resolution relating to the arrest and surrender of Mr. al-Bashir.
Professor Dire, thank you very much for your time. We'd like to apologize for that lie. We had to speak to Professor Dire because he was at The Hague during these hearings. If you'd like to join us in today's discussion, you can call us on 011 714 5497 or 5498 or tweet us at Rights and Recourse. Alternatively, you can email your thoughts to rightsandrecourse@sabc.co.za. Stay with us. You can. It's interesting interview. Ottilia, I think you can hear us now. Ottilia?
Yes, I can hear you.
Did you hear that discussion? It was very difficult. Did you hear that discussion with Professor Dire?
I did. I did hear it. It was a bit strained, but I did hear it.
Okay. Yes, yes, yes. Welcome back as we discuss South Africa's appearance at the Article 87, subsection 7 hearings at the ICC on April the 27th this year. Let me go to Pretoria. Ottilia, good morning, good afternoon. The question is, does the ICC hold these kinds of hearings with all member states who do not comply with their obligations?
This is the first time that the ICC has called for any such hearings. But one of the reasons perhaps which Professor Tladi did not speak about is the fact that unlike previous cases where the states themselves submitted their written reasons to the court immediately after being requested to do so, South Africa in December of 2015 asked for a postponement on the basis that they needed to exhaust internal remedies first before they would be able to give reasons to the International Criminal Court. And they spent 2016 doing exactly that, both at the High Court and the Supreme Court of Appeal. And then the appeal that they sought to have at the Constitutional Court, but then neglected in November of last year. So the International Criminal Court coming out in December to say, now let's have a hearing on this matter, is really as a culmination of the events before that. South Africa's case is peculiar because the way in which the South African executive has handled this process has been different from how the other countries have.
I just want to go back to something else, Anneke, and that is, it would seem to me, the same question I asked Professor Tladi, because it seemed to me the ICC did not mince its words. Judge Tarfusa saying there was no ambiguity about South Africa's obligation to arrest al-Bashir and no provision in the domestic law to arrest, but he seems to have a different view.
I think here's where the problem comes in, is that it's very clear from the Supreme Court decision that under South African law, South Africa had an obligation to arrest in terms of the implementation of the Rome Statute Act. And that obligation exists for whoever still arrives who has a warrant of arrest out against them. And that situation will not change. What South Africa sought to do was sought to avoid accountability at the ICC by saying, well, on an international level, we shouldn't have to worry about the South African legislation. Let's look at customary international law. And customary international law says, yes, there's immunity for heads of state. And the problem with...
That was the argument that was driven by, Jeremy Gauntlet SC.
Yes, which the Supreme Court sort of latched onto, but in the end said that's not relevant to the actual determination because the issue purely deals with, can be decided purely on local domestic legislation. I think the concern here is that if you look at South Africa's argument at the ICC, what it said was that the customary international law allows for immunity for heads of state. There is no immunity for heads of state of member states to the ICC, which then leaves all those countries who are not member states, and their leaders and senior government officials and heads of state then has immunity. So you have this weird situation where Sudan was referred from the Security Council. Sudan itself is not a party to the ICC. But by South Africa's argument, therefore, President Bashir has immunity before the ICC. If you extend that argument, it would basically mean that any referral by the UN Security Council would never lead to anything against senior members or heads of state.
Let's talk about this referral by the United Nations Security Council. Jeff, I've always argued with our friend in Pretoria that I don't understand why would the United Nations Security Council have to refer cases to the ICC when the majority of the members of the United Nations Security Councils have not ratified or signed the Rome Statute.
No, it's a good point, but you also have to remember that several of the cases that have led to indictments were referred to the court by the African governments themselves, and the African governments in supporting and helping to set up the ICC wanted a place for international justice. And I think, the concern now that the international community has, including my own country, Canada, which has been very concerned about this as a sort of a founding member of the ICC, is that if South Africa pulls out of the ICC, there's kind of a vacuum. There's nothing else. The African Union has been trying to set up this African Court of Justice and Human Rights, but it doesn't exist. It hasn't been ratified. So in a way, South Africa would be pulling out and then saying, well, we're going to leave the world with nothing. So I think the view of supporters of the ICC, like Canada and many others, is that if there are concerns about how the ICC operates, then the response is to strengthen it rather than walking away or weakening it by withdrawing. And South Africa is a very important country in the world. It's seen as being a moral leader since 1994. And Nelson Mandela talked about human rights being at the center of South Africa's foreign policy. And so Canada and South Africa were among sort of the earliest supporters of the ICC. So countries like Canada, I think, are very concerned if South Africa would then, having supported the ICC, would walk away instead of taking the opportunity now, which they have, to strengthen the ICC.
I see there was real concern from Canada. You reported in one of your articles that Canadian Justice Minister Jody Wilson-Raybould actually offered to assist South Africa and find out what are the problems. Probably we can tackle and take these issues to the ICC together.
Yeah, I think Canada, like a number of other countries, sees that this is actually a good moment to step in and try to mediate, try to address South Africa's concerns, and persuade South Africa to stay in the court and to strengthen it rather than to weaken it. This is the moment now because South Africa has withdrawn, as you pointed out, withdrawn its notice of withdrawal and withdrawn its legislation as well. So now is the perfect opportunity for South Africa to take the fact that many countries in the world are sympathetic to South Africa and want to hear South Africa's concerns. And they just argue that South Africa should be constructive and try to improve the court rather than weaken it or potentially even destroying it by leading an African walkout.
Otilia, there is something that concerns me really. I don't know whether Professor Dire addressed it, Dire Tladi addressed it. The issues around the fact that South Africa seems to be hiding behind domestic law. He didn't respond to the domestic law, and I thought in my own assessment that he must be talking about the Rome Statute Implementation Act number 27 of 2002 rather than another domestic law.
So South Africa has the implementation of the Rome Statute Act, and it also has domesticated the Diplomatic Immunities Act, which were the two laws that the South African executive argued with, and basically said that those two were in conflict. And obviously, at least for the High Court and the Supreme Court of Appeal, those arguments were in large part rejected on the basis that if you take a reading of the implementation of the Rome Statute Act together with the Diplomatic Immunities Act, the one speaks to the functions of the president and the other one speaks to criminal responsibility and whether or not a person can be charged for these international crimes. Now, perhaps the question that we ought to be discussing, in addition to the domestic law, but also the conversations on international law, is why is it that we are so invested in ensuring that certain people are immune from prosecution? And that is a conversation that perhaps is not strictly within the remit of the law or even in terms of just international politics, but I think it is a conversation that we have to be forthright about and that we actually do have to have, because we cannot keep having discussions around which parts of the law speak to what, without understanding, one, why they were included in the statutes themselves, but also why certain people are invested in ensuring that people are immune from prosecution.
We'll continue our discussion, but let's take this call from D from Namibia, a regular caller to our show. D, good afternoon and welcome to Rights and Recourse. I understand Namibia has also voiced its objections to the ICC.
Yeah, good morning, Dumele Matezli. How are you doing?
Well, thanks. How are you, D?
Good. Good afternoon to the guest also in the studio with you. It had been a long time I didn't call in. So I would like to know the United Nations Security Council. if any African member of Africa is also a member of the United Nations Security Council in the decision-making group, are we involved there? What is in the International Court of Justice ingredients that are found there that are not in Africa? We have a law in Africa. Why can't we have our own court that is judging our own African leaders who are committing crime? Instead of having International Court of Justice, which is even far from, what is a good ingredient that we get from there that are not in our African countries? Thank you very much, Razek.
Thank you very much. That's a question we have raised here before. Jeff has raised that question that the African Court has not been ratified. And the other thing that Dee is asking is, what about why is no African country a member of the Security Council? Earlier, before we started the program, I raised the issue of the fact that South Africa could have been a member of the Security Council had it not been for apartheid, because South Africa is a founder member of the United Nations.
Well, I think many African countries are members of the Security Council on an elected basis. The point is that there's only 5 permanent members of the Security Council, and it is a legitimate issue that people have been debating for a long time. But you know, the question here is the ICC, not the Security Council. I mean, the Security Council has referred some cases to the ICC, but it's still the ICC which makes decisions about investigations. And you know, it's true that there's been so far only African individuals who've been indicted by the ICC, but it's important to remember that the ICC is trying to go to other countries, and it's been looking into, for example, U.S. actions in Afghanistan. There's an investigation, well, they call it a preliminary examination that's been going on, but it's been gathering a lot of evidence about alleged U.S. torture and human rights abuses in the Afghanistan war. It's been looking into British actions in Iraq. It's been looking into Russian actions in Georgia. So there is scope, I think, for the ICC to go beyond Africa, and it is already. And the solution, I think, is to find ways to address the concerns of member states and to strengthen the ICC and to make sure that the principle of international justice is more widely respected. It's true there are flaws. It's true that there are countries that don't ratify and seem to be exempt from investigation. But critics tend to say that, oh, the U.S. is immune from the ICC, but in fact, it is being investigated for its conduct in Afghanistan because Afghanistan is a member of the ICC. So there is more scope, I think, than the critics acknowledge.
And perhaps to add, sorry, on the African Court itself, I think yes, we'd love an African court to deal with issues within Africa. But at the moment, it's not just the issue of there not having been enough ratifications, and it will take quite a few years before the court actually comes into operation. But the court itself provides for immunity for heads of state and senior government leaders. So it's not as if we're going to take President Bashir to the African court. So that in itself, yeah, there's many victims who will not get justice through the African court as it stands at the moment.
But by the way, the South African government was going to challenge the ruling of the North Gauteng High Court at of the Supreme Court of Appeal at the Constitutional Court. Where does that leave you, the Southern African Litigation Centre?
Well, what it basically means is that the Supreme Court of Appeal judgment stands, and for us that means that South Africa has an obligation in terms of the Implementation Act, while the Act is still with us, to arrest anyone who has an arrest warrant against him and who comes into South Africa.
Otilia, there is something that was raised by Professor Tladi that has to do with the referrals to the United Nations Security Council. I think he said something to the effect that the United Nations Security Council is not necessarily enthusiastic in hearing these referrals, probably because of something that I mentioned earlier, that they themselves, a majority of the members of that Security Council are not signatories to the Rome Statute.
I think it's perhaps worth clarifying that it's the majority of the permanent 5, not the majority of the members of the UN Security Council. The remaining 10 are, in cycles, and it depends. Sometimes they do have a majority member states to the Rome Statute, and sometimes they don't. But I think one of the key issues and one of the constraints around the way in which the relationship between the International Criminal Court and the UN Security Council has been set up is that it was set up essentially on the basis of good faith, that the UN Security Council would act in the interests of peace and security in respect not only of its own referrals, but also where, for example, a state is referred back to the UN Security Council in respect of non-compliance. But what we have seen, at least since 2011, is that the UN Security Council, in large part due to the role of China and Russia, has been hesitant to engage on any issues around the International Criminal Court period. So what we have is the last referral by the UN Security Council to the International Criminal Court was that of Libya, which incidentally was a resolution that was championed by South Africa at the time, South Africa having been part of the UN Security Council at the time and having voted for that referral as well as subsequent resolutions around Libya. The problem comes in that of the permanent members, those that want to veto any resolution on the International Criminal Court can do so, and they have done so in the past. So perhaps it's a bit unfair to say that all members of the UN Security Council are of the same mind, but it is important to note that at least China and Russia, that are powerful members on the UN Security Council, have vetoed decisions related to the International Criminal Court since 2011.
Well, let's take this call from Victor from Johannesburg. Before we continue, Victor, good afternoon and welcome to Right and Recourse. Yes, Victor, could you speak up? We can't hear you. Can you speak up? Are you there, Victor? Yes.
Yes, how are you?
Are you there? Can you speak up? I'll refer you back to my producer so that we can get a clear line for you. But in the meantime, Anneke, it would also seem that the International Criminal Court, in making its case against South Africa, places a great deal of emphasis on South Africa's own human rights record and even quoting the Freedom Charter.
I mean, I find the whole situation very ironic. If you look at the crimes against humanity defined in the Rome Statute, apartheid is a crime against humanity. So more than any other country, we have experienced apartheid. We know that there's a need for, when you're in a situation of a dictatorship or a regime who doesn't care about victims, you need outside tribunals to be able to step in where possible, or at least provide that option for victims. The UN observer mission last year to Sudan mentioned that there are great similarities in apartheid and what is happening in Sudan itself at the moment, where you have Darfurian villages being destroyed and right next to it other villages being set up by... So it's so sad that we're willing to defend Bashir as the African head of state, but we're not willing to look at the atrocities and the human rights violations and the apartheid that's happening in Sudan, and as South Africans willing to take a step and say, actually, well, we've been through this is not good enough, we want to take a step. And I think we're very powerful, as you've said, within the African bloc, and the African bloc are quite a number of countries. So we have power within the ICC to try and push the sort of high moral values to say, listen, we need to act with decisiveness, we need to act quickly. It's not okay for cases to drag through the ICC system. It's not okay to not having dealt with apartheid and occupied Palestinian territories. You know, like, we have a voice, we have views.
Funny enough, Jeff, the ICC says in its heads of argument, it emphasized the fact that South Africa's participation in peacekeeping missions in Africa was largely due to acts of impunity by African heads of state. Therefore, it has a direct knowledge and understanding why actions by the courts are necessary.
Yeah, well, I mean, that's the whole issue of impunity, and the concern is, internationally, that heads of state should not be above the law, and that was one of the principles of the ICC when it was set up. The idea that senior officials and powerful people should not be above the law. And it's a bit disappointing, I think, for the international community to see South Africa sort of leading the charge against that principle. As Annika said, in the African Court of Justice and Human Rights, which has not been set up yet, has not been ratified, but the African Union has taken a position that that court should give impunity, basically, or immunity to heads of state. And that once you start chipping away at the concept of nobody being above the law, then it's a very slippery slope, and it could be quite a dangerous precedent to have politicians basically above the law.
Let's take this call from Matenja from KZN. Mr. Matenja, good afternoon and welcome to Rights and Recourse.
Good afternoon, Tumile.
Yes, sir.
Yes, no, Tumile, I would love just to add something about this thing you're debating about. You see, to me, I'm a little bit perturbed where the International Court would love to call the African leaders to account. Where on several occasions we've seen and we have heard where more especially America when they were attacking Iraq. If one can ask, when you attack another country and you are perceiving they've got these nuclear weapons, but at the end you don't get anything, who is about to call that country to go to the court of law about that? Because as if now the knife is sharp to African countries. But when you turn the knife to another side, it seems like it's blunt.
Thank you, Mr. Matenja. I think I'll get Ottilia in Pretoria to answer that question. She's far more qualified than us to answer that question. Ottilia, you heard the question?
Yes, I did, Dumile. I think there's a number of things, and we've had a conversation around how the International Criminal Court can assert its jurisdiction. I'll start with the last point, which was around the United States and the invasion of Iraq. At the time of the invasion, the crime of aggression had not yet been ratified. So while it was included in the Rome Statute, it was not yet, the International Criminal Court rather could not assert its jurisdiction over the crime of aggression. The other range of crimes that were committed or that were allegedly committed, those are crimes that the International Criminal Court could look into. The challenge there is that for as long as the United States is not a member state of the Rome Statute, the only way that that could be referred is through the UN Security Council. So it's almost like we keep coming back to this point, which is that the UN Security Council, if it is meant to be working in the interest of peace and security, then its referrals should not be on the basis, for example, that this is a state party or this is a non-state party, rather, that exerts international influence. But at the same time, and I think Jeffrey has made this point already, which is around the cases that are currently before the International Criminal Court and how they got there. I think it would be remiss of us to ignore African agency in referring those situations. It would also be remiss of us to make as if there are no victims of any of those crimes at all. Because once we do that, and once we say until everyone is held to account, no one is held to account, then there's no point at all in terms of any justice mechanisms whatsoever. And then there was another point that he made around, obviously, the need for there to be accountability globally, but also perhaps, and he didn't speak to this, which was accountability on the African continent. And I think the way in which the Rome Statute was drafted and the provisions of the Rome Statute are actually that the International Criminal Court is supposed to be a court of last resort. What we have not seen is we haven't seen the number of African countries that say these things should be dealt with locally actually going ahead and doing that. There are some countries that have done so, but for example, in 2009, the AU high-level panel into Darfur that was headed by Thabo Mbeki recommended that a hybrid court be established in Sudan to deal with the international crimes committed there. It's 2017. close to 8 years since those recommendations, and there isn't a hybrid court in Sudan to deal with the crimes in Darfur.
Well, if you'd like to join us in today's discussion, please do call us on 011-714-5497 or 5498. Alternatively, you can tweet us at Right Recourse or send us an email about this program and many other programs and issues that you'd like us to tackle to rightsandrecourse@sabc.co.za. Stay with us. Oh no. Oh, Liz. Oh.
That's a good question. There's a number of them, but I'm sure Kenny was
What is this?
at the AU summit in January.
Oh yes, I'm coming to that question actually.
But the ICC does wait for domestic politicians and governments to deal with it, and only is the last resort. There were several years where the ICC waited.
8, 7, 6, 5, 4, 3, 2, 1.
Welcome back to Right and Recourse as we discuss South Africa's appearance at the ICC on the 7th of April this year to give account as to why they did not arrest and hand over President Omar al-Bashir. Let's take this call from Joseph from Johannesburg. Joseph, good afternoon and welcome to Right and Recourse.
Yeah, Mr. Matez, how are you?
Fine, thanks. How are you, Joseph?
I'm fine. Dumza, what I want to say is that all of us, we know about the way the UN and the ICC is planned. But what can the world do to make sure that all these countries are accountable to the International Court of Justice? Because it's unfair for other countries to commit and others don't commit. And most of the countries who are not committed to the ICC are aggressors in the world. Thank you.
Thank you very much, Joseph. Joseph is asking a very pertinent question. Probably any one of you can take that question because he says, what can we do so that the world treats everybody different? People shouldn't opt out of a situation when they don't want to be. For instance, in the case of the United Nations, they don't even want their soldiers to wear the blue berets of the United Nations.
Well, there's no question that the ICC is far from a perfect mechanism, but it's certainly far better than nothing. And even if it doesn't lead to a conviction in every case, or so far there's only been a handful of actual convictions, but it seems to me that at the very least what the ICC is doing is applying some moral pressure to these cases and applying some scrutiny. And to go back to the cases that I mentioned earlier, the ICC doing these preliminary examinations of actually the role of those so-called aggressor countries, superpowers that intervened in Georgia, Iraq, and Afghanistan. The mere, I've looked at the actual report by the ICC prosecutor on U.S. actions in Afghanistan, and it goes into some detail about the evidence of U.S. torture by CIA and soldiers, torture and other alleged human rights violations.
They dropped the other day.
Yeah, so I mean, the world is calling for greater scrutiny of what superpowers do in places like Afghanistan. The ICC is actually doing that. It may not lead to a conviction. It's difficult because of the Security Council and other factors to actually get to as far as a conviction. But the mere fact that the ICC is able to do reports, investigations, and apply pressure and apply, provide information and provide some transparency on these cases is, I think, much better than the alternative, which is nothing.
Anneke?
Perhaps to add on to that, and I think it's linked to what Otile said earlier on, is that the ICC is a young institution. I think they themselves have their own capacity problems. There's a whole lot of issues to deal with in the world. And I think the whole purpose of the Rome Statute is to